Hi everyone, welcome to today's webinar. We're just going to give a minute for folks to join us from the waiting room and then we will be getting started. All right. So welcome to today's webinar. Today's webinar will be on utility assistance, what you need to know. And before we get started, I just want to quickly tell you a little bit about the Housing Alliance. We are a statewide coalition working to increase access to safe, decent, and affordable homes for all Pennsylvanians. Webinars are free for members, so do become a member today. You can do that by visiting housingalliancepa.org/become a member or contact us at info@housingalliancepa.org for more information. Next slide. So this webinar is going to run approximately for 60 minutes, and that includes time for question and answer. We encourage you to leave questions to our incredible group of speakers today. So if you want to ask our presenters a question, please use the Q&A function. You can find that to the bottom right side of your screen. If you want to ask the Housing Alliance staff any logistical questions, you can use the chat function for that. So once again, use the Q&A function for questions that you want to ask the presenters. I also want to tell you about a few upcoming events. We do webinars every month. We have an upcoming Protecting Federal Funding meeting, which will be on Monday, September 15th from 12:30. That time is wrong. It's from 12:30 to 1:30 p.m. We also have a webinar on land banks and tax delinquent properties, opportunities, challenges, and best practices for them. That will be held on Thursday, October 16th from 12 to 1 p.m. You can scan the QR code to the right side of the screen to visit our events page, and then you can register for what you are interested in. All right, so back to today's webinar. We have speakers from PULP, the Pennsylvania Utility Law Project, with us today. We have Lauren Berman and Ria Pereira with us. Lauren and Ria, thank you so much for being with us today and sharing the incredible information that you guys have with our audience. So this webinar will have information on important utility assistance programs and other critical resources. With that, I am going to stop sharing my screen and I am going to pass it over to Lauren and Ria.
Great. Thank you so much, Chris, and thanks for having us this afternoon. We always love presenting with the group. We were actually both at the PA Rural Housing Conference over the summer, and that was a really great event. So we're definitely happy to be here. So I will be doing the main presenting. Ria, who's our supervising attorney, will be answering your questions in the Q&A. She may flag some questions for discussion. She may answer others just in the, in the chat, depending on the question. So we are intending on having some time to answer some live. If in the event, because there's only an hour, utilities are complicated, if we don't get to all of your questions, Chris will be compiling them and we will circle back with answers. So, if we don't get to you today, we will circle back and get to you, but we'll do our best. And again, my name is Lauren Berman. I'm a senior attorney with the Pennsylvania Utility Law Project. Ria Pereira is supervising attorney. And I am going to start sharing my screen and we will get going. And then we do that. Okay, very good. Okay, so as Chris said, we are with the Pennsylvania Utility Law Project. We are a statewide legal aid office, so we fall under the same sort of program as your local legal aids like Neighborhood Legal or Mid-Penn. We're a project of the Regional Housing Legal Services and a member of the Plan Network. Our mission is to secure just and equitable access to safe and affordable utility services for Pennsylvanians experiencing poverty. And we do this in many ways, more every day. We do legal representation. I represent a lot of individual clients. We also have group clients who we represent in large scale litigation. So like when a utility company wants to raise rates, they have to file with the Public Utility Commission to do so. We intervene in those cases. And try to advocate as best we can for the people that we represent. We also do education and training like this, policy advocacy at the state level, supportive services and consultations. And we'll talk a little bit about consultations because we want to be a resource. You all are advocates and we want to be a resource for other advocates as well. So today we're going to hit on energy security in Pennsylvania briefly. We're going to talk about the rules and regulations. What are the utility companies supposed to be doing? What protections do specific groups of people have? What protections do we not have? We'll talk about special circumstances, available assistance programs, a little rundown of how I think about case handling for clients who are at risk of losing utility service that I hope would be useful to you all when assisting your own clients. And then we'll talk about the dispute process and additional referrals and resources. We will be providing the PowerPoint. So if I do move quickly, which I will, and you miss something, it's okay. We're going to get all this to you. And again, we'll make sure you have my contact information for any follow-up questions. So starting off, energy insecurity in Pennsylvania. It is a problem, and it is a growing problem. So in 2024, you're looking at nearly 400,000 households had either electric, gas, or water services terminated in 2024. That is a huge number of households. Just from January to May of this year, you're looking at over 118 terminations. That's just electric and gas. And then in December of this year, or this past year, December 2024, more than 24,000 households entered winter without a safe heating source. I don't know if you guys remember last winter. It was awful. It was very, very cold for a very long time. Even as of February, over 16,000 households still did not have heat. So keeping people connected to service is a sort of a constant struggle. And you see here, this is just an electric example. This doesn't get into water, or which is complicated, or gas rates, which is also complicated. But for electric, for example, if you look here in 2006, this is all for the same usage level. If you look here in 2006, your average bill would be around $55. Now, for that exact same usage level, you're paying almost $100. So the sort of stretch that people are feeling in their utility bills and other housing is not, it's a real thing. And this is just these electric rates. This is both people who use electric for their heating and those who have a different heating source. So this is everything. If you were to pull out electric heating specifically, you're looking at even a more extreme increase. So for example, this increased, about 80% electric overall. For electric heating, you're looking at an increase from about $170 a month in 2006 to $350, over $350 in 2025. So that is over 100% increase. So especially for people that have primarily electric heating, like they don't have gas, they don't have a deliverable fuel, those increases are really, really significant and are taking a massive chunk out of people's, sort of month-to-month bills. And we see it especially increasing with people who are over the income limit for the sort of the traditional assistance programs, who had been able to sort of make it work from month to month and now are just really not able to do that. So with that sort of background, we're going to talk about the situation in Pennsylvania and what can you do for your individual clients and people that you're advocating for. So in Pennsylvania, this is a bit of a simplification, but we basically have two giant chunks of utility services. They can either be through the Public Utility Commission, the PUC, or you might call it the Commission, the Pennsylvania Public Utility Commission, the PUC. That agency is the state agency that regulates the regulated utility. So that's going to include your large electric, natural gas, and water companies. So PP&L, UGI, Duquesne Light, Columbia, PECO. They are subject to jurisdiction of the Pennsylvania Public Utility Commission. There's a complaint process through the PUC. We'll talk about that at the end. And there are very specific rules for billings, collections, and terminations. And the electric and gas utilities must offer assistance programs with very specific components. We'll talk about those also. But there are rules for them and they're mandatory. Other utility service providers could be co-ops. They could be most commonly municipal utilities, with a couple of exceptions in Philly and in Pittsburgh. But so basically, like if you live in a borough and your water and sewer service is provided by the borough, then that is a municipal service, and they are not subject to the Public Utility Commission rules. If you have a complaint, you have to go to the Court of Common Pleas. That's not to say there are no rules. There are rules that they have to follow. We will talk about those. Water Services Act is designed in part to protect tenants from having to pay for previous tenants' bills. There's the Utility Services Tenants' Rights Act. There are other broad consumer laws. But what there are not are standard billing, collection, and termination rules. So they don't have to bill a specific number of times per year or after a certain number of days. The collection processes can kind of be what they want, and there are not the same protections or notifications required for terminations, and there's no requirement to offer any sort of assistance program or payment arrangement. That said, some of the larger municipal authorities do have some type of assistance program. They do and should also all have policies, public policies. So at the very least, they need to be following their own policies. So if you are trying to help someone that's dealing with a municipality or a borough or something like that, look to see what those policies are, because at the very least, they do need to be following those. So we're going to talk about some rules and regulations, and I will do my best to specify which are relevant to the regulated utilities versus basically everyone else. So this is all regulated utility information here. So when can your service be terminated? Well, your service can be terminated for non-payment of an undisputed delinquent account. Undisputed is underlined there because we will talk about disputes. But basically, undisputed means you agree that you owe this money and you just have not been able to pay it. So it could also be failure to comply with the terms of a payment agreement. So you enter into an arrangement and you fall behind on it, they can shut you off for that. Completing a security deposit. We'll talk a little bit about those rules. They can't charge everyone a security deposit, but if you are billed a security deposit and you don't pay it, they can shut you off for that. And then failure to permit access to equipment. This does come up sometimes. We generally stay away from that because it's often viewed as a safety issue and there's not really much to do. But essentially, if the regulated utility wants access to a meter and it's in your home, you do need to allow them access in a reasonable time. You do need to allow them access to that equipment. Regulated utilities cannot shut your service off on a Friday. They cannot shut you off on the weekend. It is unlikely that they would shut you off on a holiday Monday. I can't say it never happens, but I've never seen it happen. So terminations only Monday through Thursday. So if you make it to Friday, you have over the weekend, but they could show up on Monday, and there are notice requirements. So there's a 10-day written notice, so that generally will get sent to you in the mail. I'll note here, though, that whether you receive the notice or not in a timely manner is not the responsibility of the utility company. So as long as they issued it 10 days before, it doesn't matter if you get it on day 11. And we know that happens sometimes. So 10-day written notice. The notice is valid for 60 days. So if it's dated September 1, that means they can shut you off starting September 10 or 11. And for another 60 days after that. So they don't expire just when that day is up. They are good for 60 days. There also needs to be a 72-hour attempt. That is typically a voicemail. And then there's a last knock, which means right before when they're actually there to shut you off, they do have to attempt to make personal contact before they shut you off. I don't know how often that happens, but that is a rule, and they are supposed to do it. So then we have the winter moratorium, which is going to be here before we know it, hopefully. So low-income households are protected from termination from December 1 through March 31. So this applies to regulated utility companies, although some unregulated companies may have similar protections, but they're not required to. So gas, electric, and heat-related water service. So if you have radiators, for example, you need water in order for your heat to function. Your water would be included in that. And this is for households at 250% of federal poverty or below. That's a much higher limit than most protections that we're talking about in most programs. And the utility has to know that the household is low income. So we always recommend, we want our clients to make sure the utility companies know where they're at on the income scale, so they're getting access to everything that is available to them. So again, report your income to your utility company. Bills do continue to accrue over the moratorium. So there is a acceleration of shutoffs starting in April, because they haven't been able to shut off over the winter. That winter moratorium is really a safety protocol, a sort of a harm reduction rule, but the bills keep coming. They will become due. You can absolutely get shut off in April for bills that were not paid in December, January, February. If your service is off before the moratorium starts, it's not necessarily going to get you back on. But if you are accidentally shut off, if you should be protected and you're not, maybe just because the utility doesn't have your income on file, that should get you back on. So if you get shut off on December 2nd and you know that your income is below 250, call the utility company and let them know they should turn you right back on. If not, I would file a complaint with the Public Utility Commission. And we'll talk about LIHEAP here coming up, but they start sending out shut-off notices as early as February, late February, early March, so that those customers can get LIHEAP crisis grants before the moratorium ends. So payment arrangements. Agreeing to a payment arrangement means that you accept that you owe that money to the utility. So it's sort of easy to say, well, if you think that amount is wrong, you shouldn't accept the payment arrangement. Technically true, but on the other hand, you may not have a lot of other options. So if you do not believe that what you are being charged is correct, you should not be agreeing to a payment arrangement for that. You should probably be filing a complaint with the commission. But ultimately, once you enter into that payment arrangement, that debt is yours. The arrangement can be spread out over a specific period of time. There's usually guidelines based on household income. It's usually anywhere between 6 months and 60 months is about the longest that we ever see. But again, that's a place for negotiation for sure. It never hurts to ask for a longer one. I will also say, if you are calling a utility company to enter into a payment arrangement, do not do it through the automated IVR system, because you will not get as good a one as you probably could get if you talk to an actual person. So that's sort of I should have that in red on here somewhere. Do not enter a payment arrangement with an automated system. At the very least, make sure that you talk to a person. And the utility companies can offer as many arrangements as they want for any period of time, but they do not have to. There's a big sort of gap between what they have to do and what they can do. So, they do not have to offer you more than one, but they certainly can. And this is a good time to talk about occupant liability. So agreeing to an arrangement, again, means that you accept that you owe that amount. Occupant liability is a rule definition that we have in Pennsylvania, that any adult who's living in the home at the time the debt is accrued can be held responsible for that debt. So whose name the service is in doesn't necessarily matter that much. If you are an adult household member, you can be held responsible for that utility debt. It could come up when you try to move. It could come up if the person whose name service is in tries to move. It could come up. There is an exception to that for people who have a protection from abuse order. We'll talk about that in a little more detail. But essentially, it's not just if service is in your name. It's if you're an adult living in the house when the debt was accrued, you can be held responsible for that debt. And then you can also so that's for company payment arrangements. You can also get a payment arrangement through the Public Utility Commission. We'll talk through the informal complaint process. It's very straightforward. There's an online form. You can also just call, and it's a relatively brief phone call. So it's not, it's a very easy, should be an accessible, easy thing to do. If service is either on and you have a shut-off notice, or it's been off for less than 30 days and your income is 150% of FPL or below, the commission will give you one 60-month payment arrangement. But it's one. So if you had a payment arrangement 5 years ago, you may not get another one. If service has been off for more than 30 days, which we see for gas, frequently because it's, especially over the summer, like it's just not the emergency that's right in front of you. That if gas has been off for more than 30 days and income is 150% of federal poverty or below, you get one 24-month payment arrangement. So not quite as generous. So these are things to handle as quickly as possible. We also encourage talking to the utility company as much as possible. The more you communicate, the better. And sort of keeping in touch, letting them know what's happening can be a good way to sort of delay delay a notice. So again, we don't, you don't want to sort of sit on that. I understand the impulse, again, especially over the summer. You can maybe just deal without gas for a few months until it gets cold, but it's going to be that much harder to get it back on when the temperatures start dropping. So here's some issues with commission payment arrangements and why it may not solve your problem. So there are a lot of restrictions on those. So if the client has been in cap and has fallen behind on their cap bills, the commission is very, very unlikely to give you a payment arrangement on that debt. So I think the way that they view it is like, well, that you were in cap, you were getting an affordable bill, out of our hands. So, which we know that's not the case, but I think that's sort of the viewpoint there. However, with cap debt, the amount that you may need to avoid a termination may be a lot less than what's listed on the termination notice, because on the termination notice, they may just give they may have said, okay, well, you're not in cap anymore, so here's your entire account balance, and this is what you need to stay on. So again, call the utility company, ask what the cap amount is or the payment arrangement catch-up amount is. It may be something that, is either payable by a grant, it may be something you can afford, but again, it may not be. If you get a shut-off notice that says you owe us $6,000, there may be a much smaller amount that could get you back on or prevent that termination. So again, communication with the utility company is generally always to your benefit. Multiple arrangements. Like we said on the previous slide, the commission cannot require a utility to enter into a second payment arrangement absent extraordinary circumstances. So again, this is an area for advocacy. Your clients can absolutely do themselves. I mean, if they've had a death of a family member, if they've had a significant decrease in income, if they have significant medical bills or medical situations, there are reasons that they would be able to get a second payment arrangement. It's just not guaranteed. And then bankruptcy. This has come up a lot recently. If the person you're helping has gone through a bankruptcy proceeding and it is still making payments on that bankruptcy agreement, the commission will not open a case for them. This is something we run into a couple times recently. Basically, if they're still making payments, so what happens if you include your utility debt when you file for bankruptcy, include that as, a chunk that needs to be included in that. Basically what happens is the utility company gives you a new account. So they give you a new account number, they start you at zero. However, new debt can accrue, because those bills were expensive, they're still expensive. So the commission won't give you a payment arrangement for that new debt if you're still making payments on your previous bankruptcy filing. Do I think that's just? I don't, but that's sort of where they are right now. So now we're going to talk about some special circumstances, or maybe I'll stop. Ria, has anything come through that you think we should address? I haven't been looking at the Q&A.
There is one interesting question, Lauren, that I thought required some further discussion outside of the chat. I'm happy to hold that to the end, but it is a question about if apartment complexes include electric in addition to rent, and how that works, and if there's certain payment arrangement requirements and what kind of assistance may be available to those individuals. Now, I mentioned briefly in chat that these oftentimes follow different rules and requirements. However, there are some requirements such as RUBS. Now, I think that requires further explanation what that is.
Yes, no, I think this is a good time to mention that. Yes. So yeah, it is a tricky area, I think, largely because it's sort of a new area. So what I will say, everything that we're taught, well, not everything, the vast majority of the protections and programs and regulations and all of that we're talking about now apply to customers of a utility company. And a customer of a utility company is someone who has service in their name or has had service within the last 30 days. Like if you get shut off, today, you're still a customer for the next 30 days. But after that, you're then an applicant. So we're really talking about customers here. And that means that you have an independent relationship with that utility, with the utility company, the regulated utility company. So you have a PICO account, you have a PP&L account, you have a Aqua PA account. If you are paying your housing provider for electricity, gas, water, trash pickup, any of that, you're not technically a customer of a utility, you're a tenant. And a lot of those rules are going to fall under your lease. It's tricky now. There are a lot of, I won't go too far into this, but there are a lot of different ways for a property management company to split up utility costs among tenants. There aren't a lot of regulations around it. There's a little bit here and there, but typically they can split it up how they want. A lot of them are hiring sub-metering companies. So they're hiring third-party companies who sort of take control of that. And so you might get this bundle of bills. So you're paying, a chunk, and you may not really know everything that's in there. There are ways, if you think that what you're being billed is either incorrect or just, predatory, like there are some things to do about that, but not a lot. So for individual, and that stuff really isn't covered in the utility regulations in the Pennsylvania Utility Commission regulation space. So for specific questions about that, I think just reach out to us. But that was not a short answer, but I guess the short answer is it depends. And there are a lot of ways that property management companies can pass on those costs to tenants. And there's not a ton of regulation about what they can and can't do. So that's very often something to look at in your lease, which I know is tough because, there's housing shortage. So, you kind of got to take what you can get. But it is something to be aware of how those things are paid for. Who are you paying for those services? Are you setting up your own accounts, which in my mind is preferred? So I hope that kind of answered. So, okay, so we will move on to special circumstances. So these are sort of categories of protection. And I'll note here, before we get into too much detail here, we got a question before the webinar, which thank you, by the way, for sending questions ahead of time, about specific protections for seniors. There really aren't any. There are some differences in policy that we'll talk about when we talk about the actual utility company programs, but we don't really have protections for seniors. We also don't have great protections for people with chronic medical conditions, which we're about to talk about. So medical certificates are a protection that exists. A household can obtain one to delay a termination if a household member has a serious illness or a medical condition that requires utility service. So it could be something as simple as, I have diabetes, my insulin needs to be refrigerated. And a medical professional, not the utility, decides which conditions qualify. So it's a very straightforward form, and no specific diagnosis is required. That's your private medical information. All the healthcare provider needs to say is that you need to maintain service in the home, and send that right into the utility company. If you need contact information for that kind of thing, that's a good thing to reach out to us about. We have all those numbers, fax numbers, emails, whatever. We have the forums also linked to here. So what a medical certificate does is it'll stop a termination for up to 30 days. The customer can submit a new certificate every 30 days if they pay all current charges by the due date. So that can be tough because you need it because you already fell behind, right? So obviously you weren't able to afford these bills ahead of time. What I will say though is, especially if you're in cap, if you can pay that cap bill, just your 1 month cap bill, strongly recommend to do it. Because if you aren't able to pay those current charges by the due date, you can only renew that medical certificate 2 more times. So that's a total of 90 days of protection until the underlying debt is paid off completely. So it's not 3 per year. It's not 3 per LIHEAP season. It's not 3 every 4 years. It's 3 until the entire debt on the account is paid off. So it's a very limited protection. We try to, when working with our clients, we really try to keep that as your last resort, because once they're gone until the entire debt gets paid off. And for a lot of people, that just never happens. So, again, do your best. I think it can also, even if you can't pay the entire amount, it does give you time to make some payment, and that can be really, really helpful in trying to negotiate with the utility company after. So that's also sort of a general rule. Like, if you have anything to pay, do it, because it will help down the line. Can't guarantee anything, but it makes it a lot, at least on our end, it makes it a lot easier to negotiate with that utility company if we can point to, say, look, our client is, all they get is SSI, and they've been giving you like $100 every month. May not be enough, but they're clearly making an effort. That can make it a lot easier to negotiate with the utility companies. Also special protections for victims of domestic violence. We touched on this a little bit. So this is sort of the exception to occupant liability. So for someone that has a protection from abuse order or another court order showing clear evidence of domestic violence, so this could be a custody order. I've had utilities accept a victim advocate statement. So again, this can, this is a good area for advocacy. We know there are a lot of reasons that people that should have a PFA don't end up getting one. But if you have that court order, you could, make sure the utility company knows that you have that, because it also provides some privacy protections. But basically, the victim cannot be held responsible for debt accrued in anyone else's name, even if they lived in the residence when the debt accrued. So if you have a PFA and the debt's always been in your name, or the bill's always been in your name, then typically you're looking to negotiate a flexible payment arrangement in the next bullet point. But if service was in the abuser's name or another family member's name, you cannot be held responsible for that debt. You should get a brand new account, assuming you don't have other debt in your own name from before. But you should have, start your brand new account, get you enrolled in the assistance program, and get you on your way. But again, if the debt was in your name, which happens, then that's still, the utility company should be negotiating with you fairly to get you something that you can actually afford. Typically 60 months is what you're looking at, but it can be more. There's the other protection for victims of domestic violence is an attempted personal contact. So everyone has that, right? Everyone has that last knock protection. But if the utility company knows that you have a PFA, when they come by to do that, assuming they do it, they will post notice of the property, and termination is delayed for an additional 48 hours. So it just gives a little extra time for that person to figure out what the next steps are to take. And
Lauren,
yes.
Don't mean to interrupt you. Do you mind turning your volume up just one or two? We got a comment that there may be an unstable connection, so that might help with that.
Oh no, I'm sorry. Yeah, if that keeps up, let me know and I can turn my video off too. That might help. Okay, let's see if that's better. I turned me up, hopefully. So let's see. So just let Rhea know if it's not working and she'll fix our tech issues. So moving on to tenant protection. So if the utility, so these apply to regulated and unregulated utilities. So these apply to your municipalities, they apply to your boroughs, they apply to your co-ops, they apply to everyone, whether they think that they do or not. So essentially, there's two different rules. There's DSLPA, which is the Discontinued Service to Lease Premises Act. That's for the regulated utilities. And then there's the Utility Service Tenants' Rights Act, which applies to the unregulated utilities, but the protections there's some wording differences, but they're essentially the same. So if the utility is in the landlord's name and the landlord does not pay, the renter must be notified of the debt 30 days in advance of termination. So you get a 30-day notice, not 10, you should get 30 days. They should on that notice say what were the last 30 days worth of charges. So not any past due debt that the landlord was supposed to pay and didn't, but what are just the last 30 days worth. The tenant should be allowed to pay just that last 30 days every month without taking on the debt of the landlord, maintaining your service just by paying what you're using, and protected from retaliation. So you should be able to deduct whatever you are paying for that utility, deduct that from your rent. That is a defense to an eviction. It can't prevent someone from filing an eviction, but it is a defense if someone does file an eviction for that. But again, keep receipts, as much paperwork as you can hang on to. The other protection there is that the landlord or owner cannot voluntarily request that service be terminated to an occupied unit without notarized consent. unless there's some sort of an emergency, like a water main break or something. So what that really means is that if the landlord, this is what we would call basically a constructive eviction. If the landlord calls the utility company and says, hey, shut off service to my property at, 123 Main Street, the utility company, if they know that it's tenant occupied, should then request notarized consent form, like in writing, notarized. Sometimes the utilities won't, and it's usually because they don't have that property noted as tenant occupied. So that's the other thing. Like when someone's applying for a service, or anytime they're talking to their utility company, just make sure that they know that you're a tenant. They should know if your address is different than the bill payer address, but sometimes they do, sometimes they don't. So just something to keep in mind. So if you do get shut off under those circumstances, once you tell the utility that it's a tenant that lives there, they should restore basically immediately, then go back and give you that 30 days of notice and sort of start that cycle over. And then how you sort of utilize those rules can vary. So with a regulated utility company, just call the utility company directly. It's possible you're going to get someone that's not super helpful, but ask to speak to a supervisor. They should know what these rules are. Like, this should not be a surprise to them. And they should restore service relatively quickly. And if the utility, for whatever reason, is not cooperative, the tenant can file a complaint with the Public Utility Commission. For municipal authorities or other utility providers, it can be a little tougher. Certainly attempt to inform the municipality of the situation. We'll Google around and try to find who the solicitor or the attorney is for the municipality, and just sort of send them the act. It's only like 7 pages long, and just like, here. Sometimes that works. Sometimes they're completely non-responsive. If they're non-responsive or uncooperative, we have had good luck referring people to the Pennsylvania Attorney General's office. That doesn't seem to have changed over the last couple of years. So I think that's sort of they can't sue a municipality, but we have had luck with them reaching out to speak to the solicitor directly and sort of explain what needs to be happening. I will say the municipalities seem to be much more responsive to a call from the Pennsylvania Attorney General's office than they are sometimes from a call from legal aid. So that would be my recommendation there. If the landlord physically turns off service by either disconnecting or removing a breaker box or shutting water off, that's more likely going to be a landlord-tenant issue, not a utility company issue, because the utility company doesn't really have control over what the landlord, physically turns off. So in that case, you're probably looking at something like a constructive eviction. Reach out to local legal aid for a landlord-tenant attorney. If you need a direct referral, definitely you could always reach out to me for that. One other bit of tenant protection.
And Lauren,
Yes.
before you continue, I'm sorry, we had one point of clarification I think it would be helpful to give for the group related to what USTRA and DSLPA stand for once again.
Okay, so DSLPA stands for the Discontinued Services to Leased Premises Act. That's the one that applies to regulated utility companies. The other one, USTRA, USTRA, who knows how we're supposed to say it, that is the Utility Services Tenants Rights Act, USTRA. And that's the one that applies to the municipalities, boroughs, things like that. But the protections are basically the same. And again, if anyone wants copies of those, happy to send them out. Okay, great. So the last tenant protection we're going to talk about, and this applies only to regulated utilities, so this is only the big regulated gas, water, electric companies, is foreign load. So essentially a foreign load is when you have let's say you're in an apartment, let's say you're in a house that was converted to apartments, which is very common, especially like up in the Northeast, these old houses that sort of get broken down into units. If you're in like unit 2 and your lights go out, and then you realize, oh wait, the hall light also went out, and so did the porch light, and so did the light in the basement. I wonder if those are all on the same meter. That may be a foreign load. So basically anything that you're paying for that's included, like that runs through your meter, that isn't your actual unit, you should not be responsible for. So if a tenant is suspecting that there is a foreign load, they can contact the utility directly to request a foreign load investigation. You can just call them and say, hey, I think there's a foreign load. They'll send someone out, they'll do the investigation. If they find a foreign load, the utility company will transfer service and any existing balance on the account into the landlord's name. They do not have a choice of whether to do that or not. So if someone is dealing with a landlord that they've had issues with in the past, sometimes what I'll recommend is that they reach out to their local legal aid before they do that, just to get in touch with a landlord tenant attorney, to sort of let them know what's happening. Because once you call that utility company, they, again, if they determine there's a foreign load, they are required by law to take service out of your name, put it in the landlord's name with all of the debt. The landlord is then responsible for the full bill for that residence until they remove the load from the shared common area. So rewiring, whatever they have to do. And the tenant is only responsible for the utility bills going forward after the foreign load issue is resolved. So again, we want people to exercise their rights. You should not be paying for service that is not for your unit. However, we do realize that this can put tenants sometimes in sort of a difficult situation. So we just want to make sure everyone knows, any questions about that. Also, you can always feel free to reach out to me. Any questions on any of that before we move on to the assistance programs?
Lauren, there is one question we can answer, I think, live, and I'm actually going to drop it in, hopefully with a little bit of luck, the chat to you, and this is specifically
great.
related to payment arrangements and how they interact with CAP, specifically for PICO. And if someone has a payment arrangement already, but they would like to be in CAP, how that works in practicality.
That's a great question. So it sort of, it depends. So if the person is on a payment arrangement and they've never been in CAP before, maybe they had a decrease in income or just no one ever told them they should enroll in CAP, the enrolling in CAP will deactivate your payment arrangement. So basically when you enroll in CAP, we'll talk about this actually, this is a good time to do this because I'm going to go to the next slide because we will talk about this. So when someone enrolls in CAP, basically whatever debt they have, whether it's in an agreement or not, will get frozen, set aside, and will get forgiven over time. So yeah, if you've never been enrolled in CAP before, but you're on a payment arrangement for past due debt, when you enroll in CAP, that payment arrangement should be deactivated. However, people do tend to come in and out of CAP, and people will fall behind on CAP bills, even if the bill is designed to be affordable. Sometimes it's not, right? Like things come up when you're living, at 150% of federal poverty or below, like any little thing can throw your entire month off. So, it's, if you have come in and out of CAP and you want to get back into CAP, you may have a debt that the company will not defer, because a lot of those deferrals are basically once in a lifetime. There are some exceptions here and there, but for the most part, you get one, like you get one deferral. And if you accrue debt after that, like maybe you came out of CAP, you went back into CAP, now you have this chunk due before you're back on your CAP bill. Some companies, PICO, will do a payment arrangement for that debt on top of your CAP rate, which means you're paying your CAP bill, let's say, it's $45. Your CAP bill is $45 a month. If you have other debt that PICO would not set aside, would not defer, you very well could end up with a CAP payment plus a payment arrangement on top of that. Even though that's not ideal, it's still probably better than not being in CAP, depending on what those bills are, because it's, often the CAP bill is going to be less than your actual usage bill, because otherwise you're just paying your average, you're just paying your usage bill. So yeah, it can kind of go both ways. So if you're seeing someone that has a payment arrangement on top of their CAP bill, it means they had some chunk of debt that could not be deferred, either because it was like a second or third CAP enrollment, or because it's debt that they fell behind on while they were already in CAP. So that's a great question and very good timing for that question. Do you think that's good, Ria?
I think that's great. Thank you.
Okay, great. Yes, no problem. Just want to make sure I'm answering the question. So here we're going to do a rundown here of these are the utility run assistance programs. So again, these are regulated regulated by the PUC. Every regulated utility, electric and gas, are required to have these 4 components to their universal service programs. Water basically has these as well. Usage reduction, we're getting there on the leak programs, but water is just a little bit different. It's newer. So the programs aren't quite as developed. But on the other hand, the eligibility is at 200% federal poverty for, we're talking about water, we're talking about PA American, Aqua PA, Veolia, PWSA, which is just here in Pittsburgh. They all have programs that very closely approximate these. So, if you're enrolled in PP&L's On Track, you should also be enrolled in UGI's CAP, and you should also be enrolled in Aqua's, I don't know what they call it, Helping Hand program. So yeah, so if you have one of those regulated water companies, again, those are younger programs, so the enrollment rates are really low. So, to get the word out about the water assistance for sure. Water is real expensive. But so basically what you're looking at, there's sort of four components of a universal service programs. So CAP is the big one. So eligibility is usually at 150% federal poverty. The exceptions to that are the water companies and People's Gas out here in Pittsburgh goes up to 200%. Everything else is at 150, same income level as LIHEAP. Those bills, they basically will set a bill will cap it at a percentage of household income, which is designed to be affordable. It's more affordable. They're not always affordable. If your usage bill is lower than that, you should be getting the lower bill. They should always be giving you the lower option. You also have arrearage forgiveness. So any debt that you have when you enroll into CAP for the first time will be set aside, frozen. They won't collect on it. You don't really pay towards it. It just, every time you make a CAP payment, you get a chunk of your past due balance deferred or forgiven. For the first energy companies, so like MetEd, Penn Power, West Penn Power, Penelec, they have a 12 months. So if you keep up with your CAP payments for 12 months, it doesn't matter whether you had $500 deferred or $10,000 deferred. It will be forgiven. Most are closer to 36 months, some are 24. So again, every time you make a CAP payment, even if it's not on time, you will get the forgiveness, but you got to keep paying to get the forgiveness. They all also run a hardship fund. So these are either at 200% federal poverty or 250, depending on the company. There is typically a sincere effort of payment requirement. These can be negotiated, but usually they're looking for either like 3 CAP payments or $150 within the last 90 days in order to qualify for the grant. The one very limited protection that seniors have here is that for a lot of them, they reduce that amount for someone that's, I think, 61 or older than 61, 62 or older. I mean, they phrase it differently. So that's your senior protection. The grants are basically usually between $500 and $600, either to prevent termination or restore service. So you typically have to be off or have a notice. Once per year per household. There are some exceptions to that. UGI and On Track, I think, will do that up to $600. So like you can get an Operation Share grant for $200 in February and for $400 in August, right? As long as you don't go over $600 within that year. The issue with the hardship fund grants is, one, they're often not enough to solve the problem. 2, they run out of money. So they get funded in October of every year and basically go until funding runs out. And a lot of them are funded by county. So like you may have funds available, and like for PICO, I happen to know right now is out of funds in Delaware County. They still have money in Philly. So, there could definitely be some inequities there. But they're funded in October until funding runs out. A lot of places are out of funding right now. And those can be, sort of braided together with LIHEAP, other assistance, customer payments, whatever, to sort of solve the problem, resolve the shutoff notice, something like that. Also, low-income usage reduction program, which are basically weatherization services at no cost to the customer. I think everyone, goes up to 200% FPL for that now. And they should be, or will be soon, and they should be working together with, like, the gas company should also be working with the electric company, and they should also be working with county weatherization, like all at the same time, to make sure that they're getting as comprehensive measures as possible into the homes, with, as few trips as possible, so you don't have people coming in and out of your house for years. But usage reduction is really good. Not only does it lower the discount program cost, but it can make your house more comfy and safe, and that's very, very good. They also have CARES it's required. I don't know how much. It depends on the utility how much they do, but essentially they're like case managed and referral. So if you have someone that needs a little extra explanation on their bill, or someone who has some accessibility issues, that would be a reason to call the utility company and ask to talk to a CARES team member to see if they can help someone with special circumstances if they need any additional assistance. So LIARP and CAP. So basically we're just talking about electric here. This doesn't apply to gas, doesn't apply to water. For the electric companies, all electric companies have a maximum amount of subsidy or credits that a customer can receive in a program year. So basically, like if your bill is pretty low, but your usage is really high, you could run out of that discount before the end of the year, and then you start getting really big bills that you cannot afford. So getting LIARP services to low-income customers with high usage in a timely manner can really, really help people stay on that cap rate. I will say there are exemptions. Not every utility company is great about recognizing all of these exemptions, but these are sort of the recommended ones by the Public Utility Commission as to why you should not be subject to that max. So oftentimes there's a process with the utility company where they'll send you a letter and say, hey, you reached 75% or 80% of your cap credit, but you're only 50% through the year. If any of these things, household member, serious illness, usage beyond the ability to control, that's most tenants, housing is condemned, something like that, there should be a process to apply for an exemption to that. And that can be complicated. So that's another thing you could reach out to us about. So there's also weatherization programs. So this is run at the county level. A lot of you are probably very, very familiar with county level weatherization. So these are administered by DCED. Eligibility is up to 200% federal poverty. Really, really depends on the county, but there can be multi-year wait lists for these. So, I usually recommend, when possible, going through the utility company first to try to access LIARP. And then, again, they should be coordinating with other utility companies to give the household the most comprehensive measures possible. And so the link here is clickable at the bottom, and that is just a list of contacts and agencies for every county for who handles weatherization. LIHEAP. So as far as we know, we're going to have LIHEAP this fall. It is not confirmed. We have a proposed state plan. And I think it looks like it's supposed to be running from November 3 to April 3. Dollar amounts have not changed from last year. The only difference is that for the crisis interface, which is the emergency furnace repair and replacement program, the state has proposed to raise the income limit to 200% of federal poverty to align it with the county level weatherization, whereas previously it was 150% of federal poverty, like the CAP, like most of the CAP programs. So LIHEAP, if the person is enrolled in CAP, they should be getting LIHEAP every year. If they're not enrolled in CAP, but they're eligible, they should enroll in CAP and should be getting LIHEAP every year. So everyone who is CAP eligible should be doing both all the time. Again, you can apply, if they have a Compass account, that's the quickest way to apply. You can always call the LIHEAP hotline, or their local county assistance office can go in person if they prefer. Apply for LIHEAP. And I know we're running out of time, so I'm going to go quick. So basically, when I'm dealing with a client, when I'm trying to figure out how to best assist them, there's usually some questions that I want to ask. First, we want to determine if they're responsible for the bill. So we've talked about a lot of situations where that person may not be responsible for the bill, right? If they have a PFA and the bill was in someone else's name, if their charges seem really high, maybe there's a foreign load going on. Is the debt more than 4 years old? There's a statute of limitations on debt. If someone's been living with a partner for 5 years and they have old debt and they're trying to move into a new house, if that old debt is more than 4 years old, it should not prevent them from establishing service at a new place. So that, just keep that 4 years in mind. So what we try to do, first thing, is enrolling in CAP an option. If they haven't been enrolled before and they're income eligible, enrolling CAP, that's going to solve a lot of problems. But there are a lot of reasons that that might not work that we'll talk about. And then we just sort of go down the line, right? Like grant assistance. Are there any special protections that apply to this person? Are they eligible for a payment arrangement from the company or from the Public Utility Commission? This is just sort of the checklist we go down. If none of those things apply to them, should they file a complaint? Anyway, is there a further dispute that they should be having? There are some reasons that enrolling in CAP may not solve your problem. One is that they're already enrolled. Like we said, bills can still be unaffordable. They may be more affordable. That doesn't mean they're actually affordable. And things happen, right? People lose hours, cars break down. If the client has in-program arrears, if they have CAP debt from a previous enrollment, those are going to have to be dealt with in some other way. If again, previous enrollments, we talked about timing. It can take a while, depending on the company, for CAP applications to be processed. So my recommendation is always get the application in as soon as possible with the income documentation as soon as possible, and call the company and say, hey, I just applied, I submitted my application. Can you place a hold on the account? Oftentimes they will place, not always, but oftentimes they will place a hold on the account to allow the assistance application to process. They should. Other issue, suppliers. I will plug here, we are doing a webinar series in the fall. We're going to be doing, and we'll send out a lot of stuff on this. We're going to be doing our webinar, we're doing our LIHEAP webinar, which we do every year. We're also going to be doing a webinar specifically on suppliers. I think Ria's going to be doing that one and I'll be assisting. And then we will also be doing one on why are our energy bills so high, which will be really interesting and I'm actually excited to listen to. So we'll be sending out information on those. But suppliers may be an issue. You cannot enroll in CAP if you have an alternate gas or electric supplier. It has to be canceled before you enroll. That is because over time, customers with suppliers pay way, 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 way more than people who are on default service. We do not recommend signing up with a supplier. To cancel an electric supplier only takes 3 days, I think. To cancel gas can take up to a couple of billing cycles. And then I realize we are almost out of time, so I'm going to fly through this. So if you have a complaint with the utility company, you have to try to deal with the utility company first. Then if you can't get it resolved there, you can file a complaint with the Public Utility Commission. Generally, people who are doing this are requesting a payment arrangement, number to call. Again, it's a very straightforward process. It should, I always tell my clients, this is not intimidating. You can 100% do this. And then if you get a decision you don't like, you can appeal it. And appealing that decision is a little more involved. We typically do not represent people in PUC complaints, but what we can absolutely do is talk through the process, the expectations, make sure you have the forms you need, make sure that you know when the due dates are, things like that. So again, if you get that informal decision back and you're like, this is not going to work for me, or they dismissed it, you have the right to appeal. Sometimes that will just get you enough time to make some payments, but ultimately, it's important to kind of know what you're asking for. Do you want to get back in CAP? How long of a payment arrangement do you want? Can you cover even your basic usage charges? Because sometimes the answer to that is no. But again, these are rights that you have. This process exists for people to use. So if you have questions about it, happy to answer that for sure. And then the last couple here are just some referrals. So if you have clients in Philly, Community Legal Services, you can always email the pulp email that goes to everyone. If you have specific questions for me, you can definitely do that. I love technical assistance. Ask me questions. I'm happy to answer questions. And then we have a lot of links for resources here. And again, we'll send this out so you'll have all this. And then last slide, if y'all want to scan that, you could get on our newsletter and you can get some more information about getting involved with utility advocacy. And we'd love to have you on there.
Lauren, in the 2 or 3 minutes that we do have left, I wanted to just run through some questions. So we got one question about whether LIHEAP people can already apply or whether they're getting notices they can already apply. There are pre-season postcards that are sent out ahead of the LIHEAP season. The
Yep.
timing of those postcards, have you heard of those being sent out yet, Lauren?
Not yet. No, I think it's typically October, maybe end of September, October. So keep an eye out because they're coming. It's going to be, this was just Labor Day. So yeah, we're getting there. But yeah, you should get postcards if you've gotten LIHEAP in the past to pre-apply. Definitely recommend doing that because things get real busy once the season opens.
Yeah. The other question we got is if there's electric service other than Pico, may CAP be available? And my answer to that is absolutely. If there's a regulated electric provider, if there's an unregulated electric provider, the assistance that is offered does vary and is often not as robust as the regulated utilities. So that's my
That's
answer
true.
to that.
That's a good
And
answer.
we, yeah. And we have one other question. It's on Pico's Customer Relief Fund. Apparently, it's difficult to find in terms of their applications.
Yeah,
Lauren,
I
I'm going
bet.
to let you field this one.
Yeah, you have to make a couple of clicks. Like if you go to the Pico website, there you can apply online, but if you go to the website or even just Google like Pico Community or Customer Relief Fund, I think is what they call it, you have to do the application through United Way, and there is a link. So you have to like sort of scroll down a little bit. There's a link to a United Way application form. So when you submit that, you will get an email saying like, okay, it's, you've successfully submitted your application. I will note, as far as we are aware, even though people have told my clients otherwise, but it is only available for people from 151% of poverty to 300%. So currently there's like, if you're in CAP, you are not eligible for that fund. Like that is the way that they have designed it. We were not consulted. But yes, there is an online application, but it is a little hard to get through. It's a couple of clicks and it's through the United Way.
And I think that's all I've seen. Oh, there's
Great.
Thank you.
potentially one
Oh,
more. Oh, there's just a thank you. So I'm going to be silent.
You're welcome.
Maria, go for it. It was a thank you. Well, thank you both. This was incredible. I can see a lot of comments in the chat that are talking about how great the presentation was. So this was incredible. Thank you for sharing all your knowledge with everyone that attended this webinar. I do want to remind folks to sign up for the Pulp newsletter so that you can stay updated. There's going to be a lot of webinars this coming, the rest of the year.
It's fall. I don't I don't know. I don't know how that happened.
But thank you all. And yeah, thank you for joining us. Have a great rest of your day.
Thank you
Thanks,
guys.
everyone.
Thanks,
Bye.
everyone.